Okay, so when we left off, we were looking at something like this. When I left off in class, I ended, I think, each class about federalism. So this is from one of my, if you didn't have these notes, here you go. This is federalism, about national government keeping some power and sharing some with the states. So I'm going to move straight on now to the next one rather than redo federalism, because I don't want to take much time here. So then there's this idea of separating powers, and what that means is you've got those three branches, one making laws, one enforcing laws, one interpreting laws. You can, of course, pause this at any time to get all this information. That's not what I want to see. Here we go. So again, those are like those three branches of government. You know, here they are sort of in the tree. So this is the idea that they're separated, so you have different ones doing different jobs. So what's good about that? Well, one good thing, of course, is no one is doing all of these jobs. That would be more like the pigs, especially Napoleon in that book Animal Farm was able to do all three of those. That's why in chapter 7 there's that nasty execution, because he was able to make his own laws, get it enforced, and he was the one who decided who was guilty and who was not guilty. Moving straight over, of course, one possible problem with all this is there may be some difference of opinion about which job is really for each of these branches. Sometimes something might seem like it's one job when actually it's somebody else's. And I've typed in a couple other things that might occur as well. What if one's not good at its job? What if they hate each other? What if there's real difference of opinion between them? Then what happens? And frankly, we have some of that going on in our government right now. But the main idea is that you've got these separated out, so no one's doing all of these jobs, which is a pretty good benefit, but all the jobs are still getting done. So I'm going to spend more time, frankly, on checks and balances, which is this idea that each branch has some power over the other branches. And I can illustrate that. There we go. I can illustrate that with this diagram here. You have something really similar in your DBQ packet. I just like this one because it's a bit more colorful, but has basically the same kind of idea. So we have arrows going both ways. When we're talking about checks, think of like a hockey check when someone gets to hit someone else with a stick, stop them from getting to the puck. It's that kind of a check. Or it's like your parents checking on you to make sure you're doing the right thing. And it's meant to balance out. So we have an equal number of arrows. And in the Constitution, it's pretty well equal between which one has the most power. This is a debate that keeps going on about which one's meant to be the strongest. The legislative branch was frankly made to be the stronger one. James Madison, even Alexander Hamilton, a lot of other writers, even Federalists, did agree that this is meant to be the more powerful one. The judicial branch section of the Constitution is actually the shortest one out of the three. The executive branch, they were worried about making another king, so they didn't want it to have too much power, and again, both the other branches can check and balance the president. I want you to notice, though, for the executive branch, it's not just the president. This includes other agencies, departments, things like the Attorney General, the Environmental Protection Agency we have now, the FBI, the NSA, the CIA. A lot of those things you hear about are technically part of the executive branch. So I've magically added a couple benefits that we should notice. Of course, one is that by balancing, it makes sure that no one branch has all the power. And believe it or not, this really is meant to be a benefit, slowing down the lawmaking process to make sure that everyone thinks the law through, that things can't get done really quickly because it has to get balanced out. It has to go through that whole process, has to go through all these, has to go through a process between these branches. It makes it harder for one branch, like the president or Congress, to just do something right away. So, of course, that's also, frankly, a challenge and a problem, is it does slow down the process. And just a couple weeks ago, President Obama was complaining about just this very thing in his State of the Union address to the nation in front of Congress, because they're not voting for a lot of the things that he wants to go through. So he's frustrated by how the process gets. He's trying to get people to be put in as judges that don't get voted through. So it can be a problem as well. So I wanted to show you an example of how this process really works. And I had to go, for a really good clean example, I had to go back to 1972 when the Clean Water Act was passed. Of course, in English class, you're looking at water pollution with Enemy of the People, and later on with a movie Mr. Uriarty will probably show you. So I thought this would be a good example. Back in 1972, both parts of Congress passed this Clean Water Act. There was a lot of water pollution problems. Boston Harbor had lots of industrial waste in it, lots of other rivers too. So by using the elastic clause, which we talked about in class a few weeks ago, the elastic clause says anything that's necessary and proper, even though the Constitution didn't say you can pass water pollution acts. That's what Congress used to base this on. So Congress passed it, but the president used his powers of checks and balances. He vetoed that bill. He said, nope, I don't want that bill to go through. He said it gave the government too much power. That's, of course, one of the other principles of government that we'll get to a little bit later. But one of the other powers in this whole separation of powers and checks and balances, Congress can override the veto. I'm going to go back to that other item we had here. And again, you can see that's one of the things that Congress can do when the president vetoes something. The president can veto and checks them, but Congress can go in the other direction also. So that's what happened. There aren't, frankly, a whole lot of times when this has actually gone that way, when actually Congress has overridden a veto. This is one of the most famous ones that I thought I'd use. So they overrode it, so the law went through. So it's just as if the president had never vetoed it, actually. Okay. Zoom ahead about 12 years, and this is how the judicial branch gets involved. 12 years later, the United States government used that law and said this land developer in Michigan was breaking that law, breaking the Clean Water Act. In 1984, that land developer said, no, the U.S. can't enforce that law because the U.S. laws are only supposed to be about one state. This was about material in a lake in Michigan. So this is actually how federalism comes back involved, right? This is a guy saying, wait, the state of Michigan can control its own lake, not the United States. So the Supreme Court, the judicial branch, I'll go back to that diagram here, right? So now the judicial branch has the power to say, Congress, you shouldn't have done that. They can say that it goes against the Constitution. That's this arrow right here. Well, so I'll go back to the story. So it took about a year between that event and this event. The Supreme Court said, no, that's actually okay. Supreme Court did not try to balance out Congress on this one. And the reasoning was any polluted water affects all of us. Even if it's just in Michigan, it actually affects folks in every state. So that was their reasoning of saying, nope, that's okay. But, and this is how the Supreme Court works, is they can hear cases later. So just a few years ago, in 2006, there was a mostly new set of Supreme Court justices, a mostly new set from the people who were there in 1985. And this new set of judges said that the law cannot be used to protect all wetlands. So it's still the Supreme Court, but there was a different group of judges. And they said, nope, this law actually is partly unconstitutional. You can't protect all wetlands. And they had some complicated reasons for why. So how were there two different sets of judges? Well, let's go back to our checks and balances. In between that time, the president got to nominate judges. And in between 1985, when the Supreme Court said it was okay, and the year 2006, when this new set of judges came along, in between, you'd had some Republican presidents. George H.W. Bush of the 1980s and early 90s, and then his son, George W. Bush, from a few years ago, had added some judges to the Supreme Court who had their same kind of idea. The same kind of idea that, going back to the top here, that President Nixon had of saying that the government would have too much power. That's that Republican Party had that idea. So I use this example just to show you how this whole checks and balances ends up working out, or not working out, perhaps, depending on your point of view. Okay, two more, and honestly I'm going to do these rather quickly because I don't think you need too much more for your reflection. This is what limited government means. It means what it says. The idea is there are some things the government shouldn't be able to do, and I'm not going to get too deep into the benefits and challenges, just talking to myself here rather than a whole class discussion like I'd planned. But you can probably feel some of this in yourself. Again, this is the idea that government should be limited. A lot of this comes from those anti-federalists. This is that anti-federalist idea that government shouldn't be able to have so much power. Federalists were willing to give a bit more power to government to make sure that things were safe, but this is mostly our anti-federalists. And just to wrap up here, because we're over 10 minutes already, the individual rights section, that really refers to the Bill of Rights that we've been looking at in class, and you've been digging into a couple quite recently. So, of course, benefits include, right, like people get protected from their own government. That's something we kind of take for granted, but a lot of countries don't have a Bill of Rights. So people can't say, oh, but you took away my rights. They can say, well, what rights are you talking about? Challenges, though, the main challenge that I'll focus on here is sometimes my rights can get in the way of your rights. Something that I think is a right that I have. I could say that I've got freedom of speech about something. I should be able to say whatever it is that I want to say, but that goes against your rights of feeling safe, for example. And another one, which probably came up as you were looking in the guidebook as well, is we interpret rights differently. Second Amendment, for example, what does it mean to, can we have a gun, and what kind of gun can we have? Searches, what kinds of searches are unreasonable? What makes a search an unreasonable, if I can type the word, what are reasonable searches? It comes up with the Fourth Amendment. What is the death penalty? Is that cruel kind of punishment in the Eighth Amendment? So this is what we've still been struggling with for about a couple hundred years. But that's why I'm going to sign off here. So this is about what I would have done in class if I were able to go over this in class today.